May it please the Court, appearing for the defence, Your Honour, is Mr. Noah Nishihara on behalf of Mr. Oliver Mann. The question before the Court is, did Mr. Mann intend to arouse a fear that the indecent filming of Ms. ABBIE FERRARA would be distributed? I submit to Your Honour that Mr. Mann did not intend to arouse a fear of distribution, as the required fault elements were not present in the circumstances, and as such, my client is innocent, and there is no case to answer. To support this submission, I intend to apply Section 26DA, subsection 2B of the Summary Offences Act 1953, South Australia, to this case, which will reveal that the prosecution have not discharged their evidential burden. The first element, intention to cause a consequence, is not satisfied, because Ms. FERRARA will likely testify that Mr. Mann made a conditional threat that if the images are posted and everybody clicks the like button, then probably Ms. FERRARA or another person would change their mind. This rejects any certainty in the distribution. In addition, there is nothing in his words suggesting a likelihood of distribution. Ms. FERRARA will likely testify that if she complained, then Mr. Mann would distribute. However, I submit that she misinterpreted his words. Mr. Mann will testify that he knew his account would be banned and that his actual intention was to express annoyance, based on his view of women as always changing their mind. To him, Ms. FERRARA had consented to being filmed, and when she revoked her consent, he suggested that such persons might again revoke their complaints. It was an exaggerated and generalized comment, but falling short of a threat. It is also anticipated that Ms. FERRARA's evidence will show that Mr. Mann intended to continue their relationship without coercion. I will now address the second element, reckless indifference as defined in Section 51, subsection 4A. I submit that having only just met on the 23rd of August, they could not have recognized each other's subtle emotions. The prosecution's evidence that Ms. FERRARA was unaware of the conduct being criminal, and also blamed herself, justifies Mr. Mann's inability to realize that a risk of fear is probable, not merely possible. I submit that Mr. Mann harbored no ill will, but is facing a conviction because Ms. FERRARA now downplays her own conduct, which created the context in which those words were spoken. Therefore, recklessness cannot be proven beyond reasonable doubt. In conclusion, Your Honour, I submit that Mr. Mann's threat lacks the necessary intention or reckless indifference. That, Your Honour, concludes the arguments I wish to submit on behalf of Mr. Mann, unless there are any issues on which I may be of further assistance.